Swayam Prabha. Digital India. Educated India.
Let us now look into the third set of constitutional authorities, the Union Public Service Commission and the State Public Service Commission. If you will look into the Constitution of India, you will find that Part 14 deals with services under the Union and the states. The Public Services Commission forms a chapter of that part. There is a separate Public Service Commission for the Union and a separate Public Service Commission for the states. However, both have been dealt together in the Constitution. So, the constitutional provisions for the Union Public Service Commission and the State Public Service Commissions are common and are contained in Articles 315 to 323 of the Constitution. But for the sake of convenience, we will deal with Union Public Service Commission and the State Public Service Commissions separately. First, let us look into Union Public Service Commission. So, it is Article 315 of the Indian Constitution that establishes the Union Public Service Commission. Let us look into what the composition of Union Public Service Commission is. So, the Constitution merely states that in the UPSC, there must be a chairman and some other members. So, all of these chairmen and the other members are appointed by the president, but the numerical strength of the members who should be appointed has not been mentioned. But the Constitution mentions that at least one half of the members of the Union Public Service Commission should have held office for 10 years either under the Union government or under the state government. So the numerical strength is not mentioned, but the Constitution provides that one half of the members should have been government servants at least 10 years. The tenure of every member has also been fixed. It is either 6 years of service or 65 years of age. And the Constitution states that no member of the Union Public Service Commission shall be eligible for reappointment to that office. Now, there are three ways in which the service of a member of the Union Public Service Commission will get over. Either he will retire, or he can resign by submitting a written resignation to the president, or he can be removed from his office. The process of removal, we need to understand that a bit in detail. So, for removing a member of the Union Public Service Commission, the president has to first refer the matter to the Supreme Court. Once the Supreme Court conducts an inquiry and submits a report to the President, recommending that the member should be removed from the office, only then the President can pass an order to remove a member from the Public Service Commission. Now, what are the grounds for removal? The President has to refer the matter of removal to the Supreme Court on the ground of misbehavior. That is when the whole process of removal would be initiated. You also need to know that till the Supreme Court's inquiry is completed, the President can choose to suspend a member of the Public Service Commission from his office. Now, there are some grounds on which the President can initiate the process of removal of the member of Public Service Commission unilaterally, that is, without referring the matter to the Supreme Court. There are three such grounds. So first is if a member of the Public Service Commission has been adjudicated as an insolvent. Second, if he engages in some paid employment outside the duties of his office while he is serving as a member of the Public Service Commission. The third ground is if the President is of the opinion that that particular member is not fit to continue with the duty owing to some physical or mental infirmity. So these are the grounds on which the President can pass an order for removal without involving the Supreme Court, and this order will be considered as final. Now we'll come to the State Public Service Commissions. As I said before, the constitutional provisions are all the same. So let us try to locate the differences. So the first thing to be noted is that the members of the State Public Service Commission are appointed by the governor. And second difference is with respect to tenure. So we saw that for a member of the Union Public Service Commission, the tenure is either 6 years or 65 years of age. When it comes to the State Public Service Commission, the tenure of the members is either 6 years of service or 62 years of age, whichever is earlier. Like the members of the Union Public Service Commission, the members of the State Public Service Commission are also not eligible for any reappointment. Now, if the members of the State Public Service Commission have to resign, they have to tender their resignation before the governor. In the case of UPSC, it was before the president. In the case of State Public Service Commission, it is before the governor. But the process of removal of the State Public Service Commission members is very similar to that of the members of Public Service Commission of the Union. It is the same process, it is the same ground. It is the president who initiates it and the matter is referred to the Supreme Court, etc. So the same process is followed. But the power of suspension, which in the case of UPSC was with the president, that is exercised by the governor in the case of State Public Service Commissions. I hope that is clear. There is also something called a joint public service commission. So if two or more states want to have a common public service commission, they can pass a resolution to that effect in their state legislative assembly. And the parliament will create a joint public service commission for that states. I think the states of Punjab and Haryana had a joint public service commission for a very brief period of time. In the case of Joint Public Service Commission also, it is the president who carries forward the majority of the functions. The governor does not have much of a role to play. So how are PSCs made independent constitutional bodies? How is their security of tenure ensured? You will see that the security of tenure is ensured by making the process of removal a rather difficult procedure. Whether it be the Union Public Service Commission or the State Public Service Commission, the process of removal can only be initiated by the president, and that too with the Supreme Court's inquiry recommendation. You can also see that under Article 318, it has been provided that their conditions of service are determined by the president or the governor, depending on whether it is the Union Public Service Commission or the State Public Service Commission. But their conditions of service cannot be varied to their disadvantage once they have been appointed. Moreover, it is interesting to note that under Article 316, it has been provided that members of a PSC cannot be appointed or reappointed to that office. But Article 319 clarifies that the chairman of a Union Public Service Commission or State Public Service Commissions cannot seek any employment under any government offices once he retires or is removed from service. But when it comes to other members of a public service commission, they can become the chairman of a public service commission, but they cannot seek any other employment in any other government offices. So the chairman is ineligible for any further employment with the government, be it any government office. The other members of a public service commission are eligible for becoming chairman of public service commissions, but are ineligible for holding any other posts. Do you think this is a rather high condition of a service? Why do you think such a condition might have been imposed? Probably we'll have answer to that once we have understood what the functions of a public service commission are. I'm sure you will be all able to guess the first function of a public service commission. You must have all heard about the Union Public Service Commission exams or the State Public Service Commission exams. The major function of public service commissions is to conduct exams for appointing people to various government services in the union or the state government. If it is the union government, it will be the UPSC which will be conducting these exams. And if it is to the state government services, it will be the State Public Service Commission of that particular state which will be conducting exams. Now, the Union Public Service Commission is bound to assist states if they want to conduct joint recruitment. So, two or more states may want to conduct joint recruitments for the government posts that are there in those states. And if that becomes necessary, they may request the Union Public Service Commission's assistance. In such cases, the UPSC has to give assistance to these two or more states which are conducting such joint recruitments for government posts. This usually arises when candidates possessing certain specific qualifications for certain specific services are being recruited. Now, the Constitution states that the Government shall consult UPSC when it comes to recruitment, appointment, promotion, transfer, disciplinary matters, and even in litigations that are filed by government employees before the courts against the government. The usage of the word shall in normal parlance means that it is a mandatory condition. So this means that the government should consult the UPSC mandatorily when it comes to all of these aspects of recruitment, appointment, promotion, transfer, etc. But in a judgment called the State of UP versus Manmohanlal Srivastava, it has been ruled that this consultation is not mandatory. So it's just a recommendatory condition, and that this consultation is not at all mandatory. So what this means is that a candidate cannot challenge the decision of Union Public Service Commission just because the government did not consult the UPSC before the appointment or transfer or the promotion. So the lack of consultation cannot be a ground of challenge for the appointments. This has been held in this case by the Supreme Court. One last function of public service commissions is to render advice if at all any matter is referred to them by the president or the governor. So these are the functions of the public service commission. So as you will appreciate, these are functions which have a critical importance. It is the public service commission which constitutes the appointment and transfer and promotion in various government posts. So it is because of this that their independence is critical, and it is because of this that certain strict conditions of service have been imposed on them, especially when it comes to ineligibility for reappointment. As we saw in the case of Comptroller and Auditor General, the Public Service Commissions also have to submit reports annually. The UPSC has to submit the report to the President, who will cause it to be laid before the Parliament, and the State Public Service Commissions have to submit their annual reports to the Governor of that state, who shall cause it to be laid before the state legislature. So this is an additional accountability that is ensured. This is very similar to the provision that we saw in the case of Comptroller and Auditor General. Now let us look into another set of authorities, the Attorney General, the Advocate General and the Solicitor General. First, let us look into Attorney General for India. The office of Attorney General has been established by virtue of Article 76 of the Constitution of India. The Attorney General is considered as the highest law officer of a country. Now, he is appointed by the President, and the Constitution prescribes some conditions of eligibility or qualifications for a person to be appointed as the Attorney General. So the Constitution states that the Attorney General should possess the qualifications of the Judge of the Supreme Court. Now, what are the qualifications for a person to be appointed as the Judge of the Supreme Court? This you will find being mentioned under Article 124 of the Constitution. So, according to Article 124, for a person to be appointed as the Judge of the Supreme Court, he should be an Indian citizen. Additionally, he should have been the Judge of a High Court for at least 5 years, or he should have practiced in the High Court as an advocate for at least 10 years. Or the third condition can be that he should be, in the opinion of the President, an eminent jurist. So the condition of being an Indian citizen is first condition, and the other three conditions, either one of them has to be satisfied. So he has to be an Indian citizen, and he should have been the Judge of a High Court for at least 5 years, or an advocate in the High Court for 10 years, or is in the opinion of the President an eminent jurist. So these are the same qualifications that are required for a person to be appointed as the Attorney General as well. Now, it is interesting to note that as regards the tenure of Attorney General, the Constitution prescribes that he shall hold office during the pleasure of the President. Now, what does this mean? This means that the Attorney General holds that position only as long as the President wants him to. So, in the case of other constitutional authorities, we saw that there is a fixed age, say 6 years or 62 years of service, something of that sort. But in the case of Attorney General, he continues in service as long as he enjoys the confidence of the President. On the flip side, he can be terminated from services by the President anytime he wants without assigning any reason. There are many other authorities in the constitution who hold office under the pleasure of the president. The civil servants are an example, the governors are an example. So all of these authorities hold office during the pleasure of the president, and Attorney General is one such office. According to the constitution, his salary is also determined by the president. So what does an Attorney General do? The Constitution enumerates the functions of the Attorney General in a very broad manner. It provides that the Attorney General has to give advice to the Government of India on legal matters and has to perform duties which are of a legal character. And these duties may be assigned by the President or it may be assigned by some provision of the Constitution. Now, the President has assigned some specific functions to the Attorney General, and this has been done by virtue of an executive notification. Now, there are three such functions. The first is to appear on behalf of the government in matters before the Supreme Court. So, basically, these will be cases where the Government of India is a party to a litigation before the Supreme Court. In such cases, the Attorney General has to represent the Government of India. The second function is to represent the Government of India in presidential references under Article 143. You know that the President can refer certain questions of law which are of importance to the Supreme Court, and these cases will be heard by the Constitution bench. So, in such presidential references, the Attorney General may be asked to represent India. The third function is to appear before the Government of India, that is to represent the Government of India in high courts if that becomes necessary. The Constitution of India guarantees certain privileges to the Attorney General. Let's take a look at what these privileges are. One of the privileges is that the Attorney General has a right to audience in all courts. What does this right to audience mean? In simple terms, it means that an Attorney General can appear on any of the courts in India and represent the clients. The second privilege is that the Attorney General can speak in and take part in the proceedings of any houses of the Parliament or any parliamentary committee. He can only speak and take part, he cannot exercise any right to vote. The final privilege is that which is accorded to all the members of the Parliament, the freedom of speech. So there is no liability for anything said or any vote given or any liability for any publication which has been made under the authority of the Parliament. So this freedom of speech, which is guaranteed to other members of Parliament, that is available to the Attorney General as well. So these are the three privileges or the powers which are available to the Attorney General under the Constitution of India. The Parliament has enacted a legislation called the Law Officer Conditions of Service Rules 1987. In this, there are three types of law officers: the Attorney General, the Solicitor General, and Additional Solicitor Generals. Now, the office of Attorney General is created by the Constitution, as we have already discussed. However, the Solicitor General and Additional Solicitor Generals, these offices have been created under this particular statute called Law Officer Conditions of Service Rules. So these are statutory bodies and not constitutional bodies. Now this particular statute prescribes a term of office of 3 years for all law officers, that is for Attorney General, Solicitor General and Additional Solicitor General. For Additional Solicitor General, the term of office of below 3 years may also be prescribed. And all the three law officers are eligible for reappointment for a further term, that is for one more term. And the service of each of these law officers can be terminated by a 3 months notice from either side, either from the government or from the Attorney General or the Solicitor General themselves. Now, the statute also prescribes that the law officers are eligible for a retainer fee, office allowance and fee for the appearances. Now, the office allowance and the fee for appearances we understand. But what is this retainer fee? This retainer fee is what you pay upfront for engaging a lawyer to appear on behalf of yourself in any litigation matter. Now, the statute lays down certain restrictions on all law officers. They can only accept the briefs from government. They cannot advise any other person for lodging a case against a government. They have to seek prior permission from the government if they want to defend an accused in any criminal proceeding or if they want to accept any other appointment. They also cannot advise any other ministry or department unless that request for advice is received through the Ministry of Law and Justice. So now we have understood that the office of the Solicitor General is something that is not created by the Constitution. So out of all the authorities that we have discussed today and that we will be discussing further, this is one single authority which is not constituted under the Constitution. So how is then a Solicitor General appointed? So this is purely an executive appointment because the Solicitor General is appointed by a body called the Appointments Committee of the Cabinet. And this Appointments Committee of the Cabinet comprises of the Prime Minister of India and the Minister for Home Affairs. So this is an exclusively executive appointment. Now the Solicitor General is the second highest law officer in the country. So in the hierarchy he falls right beneath that of Attorney General. And the additional Solicitor Generals are mostly appointed for focusing the work on high courts. Now, when it comes to the function of Solicitor Generals, although the statute that we discussed earlier, that is the Law Officers Conditions of Service rules, although that statute treats all the law officers equally and does not shed much light into the functions of the Attorney General or the Solicitor General, in usual practice, the Solicitor General merely assists the Attorney General. So, in assisting also, they only appear before all courts within India. They do not usually tender legal advice to the government. The act of tendering legal advice is something that falls within the exclusive prerogative of the Attorney General's powers. So, the function of Solicitor General is to assist Attorney General by appearing before the courts, that is appearing on behalf of Union of India in courts, but they do not tender legal advice to the government. Now that we have looked into Attorney General and Solicitor General, let us come to the next constitutional authority in this category. This is the Office of Advocate General for the state. This is an office that has been established under Article 165 of the Constitution. And most of the provisions are very similar to that of Attorney General, or it is comparable to that of Attorney General. So if the Attorney General is the highest law officer of a country, the Advocate General is the highest law officer of a state. And if the Attorney General is appointed by the President, the Advocate General is appointed by the Governor. And we saw that for an Attorney General, the qualifications should be similar to that possessed by a judge of the Supreme Court. When it comes to Advocate General, he should possess qualifications of a judge of a high court. Now, what are the qualifications that a judge of a high court should otherwise have? He should be an Indian citizen and he should have either held judicial office for a minimum of 10 years or he should have been an advocate in a high court for a minimum of 10 years. So these are the qualifications that a judge of a high court should possess, and the same qualifications should be possessed by a person for being appointed as the Advocate General of a state. Now, just like how we saw the Attorney General holds office during the pleasure of the President, the Advocate General holds office during the pleasure of the Governor, and his salary is also determined by the Governor. The functions are also very similar. It is to give legal advice to the government of the state and to perform duties of a legal character which are bestowed on the Advocate General either by the President or by the Constitution. So we can say that the provisions are very comparable, and this helps us in a better understanding of the position of Advocate General. When it comes to the powers and privileges of Advocate General, we see that two of the powers and privileges that he has is common with the Attorney General. This is the right to speak in and take part in the proceedings of any state legislature, but he does not have a right to vote. We saw a similar provision for Attorney General. The second one is that of the freedom of speech with no liability for anything that is said or any vote given or any publication which is made within the authority of the state legislature. This is also something that we saw in the case of Attorney General. But the right to audience in all courts, which is a privilege that was available to Attorney General, that is not available to Advocate General. Barring that, the other two privileges are available to Advocate General as well. Before we move on to the next segment of our module, let us do a quick recap of whatever we have learned so far with respect to the various constitutional authorities. The first constitutional body that we looked into was that of the Comptroller and Auditor General. His appointment is by the President, but he is not eligible for reappointment. His removal is on like manner and grounds as a Supreme Court judge, and his salary and conditions of service have been laid down by the Parliament in the statute called CAG Duties, Powers and Conditions of Service Act 1971. The next constitutional authority that we looked into was the Chief Election Commissioner. He is also appointed by the President, and his removal is also on like manner and like grounds as a Supreme Court judge. His salary and conditions of service are determined by the Election Commission, Conditions of Service of Election Commissioners and Transaction of Business Act of 1991. We also looked into the election commissioners other than the Chief Election Commissioner. They are also appointed by the President, and if you will recall, in the Constitution, it does not say that the removal is on like manner and grounds as a Supreme Court judge. That was introduced after a Supreme Court judgment was pronounced by the Constitution bench. His salary and conditions of service are also determined by the Election Commission, Conditions of Service of Election Commissioners and Transaction of Business Act. In the case of Attorney General, the President is the authority appointing him, and since he holds office during the pleasure of the President, his removal is also effected by the President by withdrawing the pleasure. The salary and conditions of service are determined by the President. We also have the law officers' conditions of service rules to supplement this. The Advocate General is appointed by the Governor, and his removal is also by the withdrawal of pleasure by the Governor. The salary and conditions of service are determined by the Governor. The last constitutional authority that we saw was Public Service Commission. So for a member of a Public Service Commission, the appointment is by the President and they are not eligible for reappointment. When it comes to removal, it is the President who effects the removal after recommendation of Supreme Court's inquiry committee. The salary and conditions of service are determined by the President or the Governor, as the case may be.